Hi, hello friends. So whatever I have my feelings, whatever I have my studies and everything, I want to share with you all, friends. So in this way now this is the fourth sem, that is 402. Okay, labor laws, labor and industrial law. In that is this is the question. What is that question? Is that explain fully the history of the evolution of industrial legislation in India. Okay, this is the question. Good. Then answer is that what is the answer? Answer is history of the evolution of industrial legislation is in India. Okay, it is to be pointed out that during the 10th century, a new branch, a new branch of jurisprudence known as industrial jurisprudence has developed in India. Okay, before the independence, okay, industrial jurisprudence existed in a rudimentary form in our country. The growth of industrial jurisprudence and can significantly be noticed not only from increase in labor and industrial increase in labor and industrial legislations, but also from a large number of industrial law matters decided by the Supreme Court and High Courts. That's good. It affects directly a considerable population of our country, consisting of industrialists, then workmen and their families. Those who are affected indirectly constitute a still larger bulk of the country's population. This branch of law modified the traditional law relating to master and servant, and had cut down the old theory of laissez-faire based upon the freedom of contract. Okay, in the larger interest of the society, because that theory was found wanting for the development of harmonious and amicable relations between the employees and employees. Individual contracts have been in many respects substituted by a standard form of a statutory contract through legislation and judicial interpretation. The traditional right of an employee to hire and fire his workman at his will has been subjected to many restraints. Okay, industrial tribunals can by their award make a contract which is binding on both the parties, creating a new right and imposing a new obligations consisting out of the award. Okay, so change in the concept of master and servant. Okay, it is noted that there is a change in the traditional concept of master and servant. Okay, one who invests capital is no more a master, and one who puts the in labor is no more a servant. Okay, they are employer and employees. The former may hire the latter, but he can no more fire them at his will. Okay, the interest of the employees is in many respects protected by legislation. Both are now parties in an enterprise without are yielding in the higher status of another, but as co-sharer in the partnership. Even the right of labor participation in the management has been given legislative recognition to the utter despair of the capitalist. Most of the benefits claimed by a workman are not part of his bargain with the employer, when the latter employee 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 of employed none of the not due to them on account of any contract, but of small disable is there. Sorry for that. Okay, despite that, okay, status. The industrial society all over the world has been moving during the present century from contract to status, okay. And this status, political, socio-economic, juristic status, okay, that's good. Then industrialization in India, okay, gave birth to new society. This is side heading, okay. What is that? Economic problems, okay. Industrialization in India, as in other countries, with its some new socio-economic problems. Those who control the industrial have a natural tendency of multiplying their wealth, and if this tendency not checked, the rich grows and richer, and the poor becomes poorer day to day, okay. That good. The gap between the rich and the poor ultimately grows on to the extent that it develops into two distinct classes in any industrial society. Few of whom are haves and others are have nots, okay. This economic disparity leads to a struggle between haves and have nots, the exploited. Okay, although this situation continues for some time, and it has continued to be so in our country too, but gradually the workman realistic that they could put a better fight if they get and united. This realization was closely followed by a period of industrial unrest leading to strikes and lockouts, okay. Out of the struggle between workers demanding for better share in the production and profits of the industry, and the employers hesitating part with it beyond a certain limit, have grown the recognition of certain principles which are considered to be fundamental in almost all developing countries of the world. That's good. And the fundamental principles of a solution of a struggle, okay. This is the fundamental solution, okay. The basic principles for the solution of the struggle are as follows, okay. That's good. The right of workmen to combine and form associations of unions. Then second one is the right of workmen to bargain collectively for the betterment of their conditions of service. Then third point is that the realization that economic struggle is inevitable, because it is but natural that labor would agitate for better conditions, okay. That's good. Then fourth point is that a shift from the doctrine of laissez-faire to a welfare state dispute through the participation of workers, employees, and the government. Then sixth point, the state can no more be a neutral onlooker, but must interfere as the protector of the social good. The seventh one is the minimum standards must be guaranteed through state legislation. According to Mahesh Chandra, okay, industrial jurisprudence is of great importance to all developed or developing countries of the world, because it is concerned with the study of problems relating to human relations, arising out of a large scale development of a factory system which has emerged in consequence of industrial revolution. Okay, then proper regulations of proper regulations of employer-employee relationship is a condition precedent for planned, okay, for planned progressive and purposeful of development, okay, and purposeful of development of any society as an instrument of a social policy in the present day body politic. The role of industrial jurisprudence has still gained importance. Industrial workers and their families are directly concerned with it. Okay, then industrial revolution of India. Okay, this is side heading. It is to be pointed out that, okay, the industrialization in India, as in any other company, in any other country, implies the growth of a factory system with employers and wage earners in varying circumstances. Okay, that's good. Then and with the varying characteristics, yet having some common in the features, and it is the common features that are of interest. Okay, as a consequence of the introduction of a factory system, production became concentrated in a few selected places, resulting in the increase of labor population at all such places. The village workers migrated to the industrial towns because of the difficulty of finding adequate livelihood in their native place. Okay, this resulted in disappearance of the popular village handicraft system because they could not compete with the machine made goods. The goods produced on a mass scale with the help of machines in the industries were cheaper than the goods produced by handicraft method. But the development of industry in India brought with it in great evil. Okay, great evil mass much. Okay, in as much as it changed the status of a craftsman into wage earner. Okay, therefore a craftsman had in migrate from village to industrial cities in search of employment in factories, etc. The evils of industrialization. The factory system suffered from the following two kinds of evils. Okay, one is economic evils, and second one is social evils. One is economic evils and second one is that social evils. Okay, that's good. One is economic evils and second one is the social evils. Okay, that's good. Then, okay, and the artisan that follows. Okay, what is that? First is the economic evils. The economic evils of industrialization are as follows. Okay, that's good. One is that the artisan who in the handicraft system had 1 minute, just a break. Okay, the artisan who in the handicraft system had the psychological satisfaction of providing the goods himself, become in the factory system only a render of the machine. Okay, he had to produce the goods with the help of tools and raw materials supplied by his employer, and in the workshop of the employer. In the factory system of production, only a part of goods were produced by a certain category of workers. Different categories of workers can produce different part of the same goods. Okay, that is also matter. Okay, thus the goods came in the final shape by the composite labor of many categories of workers, and two workmen is in this system and did not get full psychological satisfaction of manufacturing a product by himself, and the industry and indirectly and indirectly arrested his mental development and creative talents, etc. The wages paid in factory workers were quits inadequate meet their barest needs in the new environment, which was different from their rural life. Okay, that's good. Rural life. Then what next? Then next one is that, okay, then next is the employment of a factory. Okay, the employment of factory workers. Third point is the employment of factory workers was not secure in the beginning. Okay, that's good. They had to suffer occasionally from periodic unemployment and underemployment as it consequence of overproduction or trade cycles. A worker could be discharged by his employer at any time without assigning any reasons therefore. Okay, so these are the economic levels. Then move to second, that is social levels. The social levels of industrialization are as follows. Okay, that is, one is that workers are compelled to work in sick factories. The factories were sick not only of economic evils but also of social overcrowded cities with insanitary slums. Okay, with insanitary slums and acute housing shortage because of large scale migration of village population to industrial towns had its natural effect on health, morality and social life of workers. The second point is workers engaged with long hours a day. Okay, work on factories was very hazardous and tremendous and strenuous, with long hours duty, no rest, no facility for a recreation. Machines were taken care of by the factory owner, who had little regard for the safety and welfare of the workers. Okay, in third point is workers exposed to serious accidents. Workers were exposed to serious accident because machines were not properly streamed. Accidents were considered as normal. Okay, as normal risk incidental to employment in a factory, and the worker who was unfortunate victim of an accident lost his employment and no right to compensation. Okay, that's one. And fourth point is that workers paid low wages. Okay, so the wages paid to the workers very low. Okay, wages were the only source of their income. Of course, the workers found it extremely difficult to live with the wages and so earned by them. Okay, that's good. So by them, therefore they had to find out ways and means to supplement their earnings. Consequently, the wives and children of workmen started seeking employment. The factory owners exploited this situation and employed them in large numbers at extremely low wages without any regard to their physical conditions. Okay, that's good. The workers found it difficult to adjust with these conditions. These levels of industrialization and the lack of adjustment and harmonious relationship between the employer and the laborers created problems in the industry, which we call labor problems. Okay, then industrial relations. Okay, 1 minute. Okay, so what is the workers found it difficult to adjust with these conditions. Of course, okay, of course that should be there. These levels of industrialization and lack of adjustment and harmonious relationship between the harmonious relations between the employer and the laborers related problems in the industry, which we call labor problems, etc. Okay, then industrial relation, it is to be is to be noted that an industry is a social varied in miniature. Okay, in miniature, industries help in production and provide employment to the people of a society. Different categories of human elements are involved in an industry. The relations of these groups inter se constitute the subject matter of industrial law. Okay, industrial relation play a vital part in the establishment and maintenance of industrial democracy. The economic activity is the central field of industrial relations. Okay, the economic system of any relation affects the industrial relations, which in turn affects the social order. Okay, so this is the social levels, of course. Then growth of labor legislation in India, of course. Growth of labor legislation in India. This is a side heading. Okay, it is to be noted that, okay, of course, that the labor legislation in India grew with the growth of industry. In India, the growth of industry in India. The growth of industry. Okay, in India. One minute. Okay, so growth of labor legislation in India. Okay, it is to be noted that the labor legislation in India grew with the growth of industry in India. Okay, the grew and growth of industry. Okay, then what next? The plantation industry in Assam was the first to attract legislative control. Okay, for which one? The plantations of industry. The plantation industry in Assam was the first to attract legislative control. Okay, that's good. Okay, the method of recruitment of workers in this industry was full of hardships. Okay, workers were employed through professional recruiters. Okay, that's good. Okay, workers were not allowed by the planters to leave the tree gardens. A number of acts were passed from 1963 onwards to regulate the recruitments. Okay, these legislations protected more the interests of the employees than safeguarding the interest of the workers. The Factories Act was passed in 1881. The Factories Act was passed, and the Mines Act in 1901. Mines Act was passed in 1901. Okay, but the most important of such acts as were passed to protect the interest of the workers was the Workmen's Compensation Act 1923. Okay, some other important social security legislation are the Employees State Insurance Act 1948, the Employees Provident Funds Act 1952, and the Maternity Benefit Act 1961. Okay, laws were also made to regulate the labor management relations. Some of them are the Industrial Disputes Act 1947, the Trade Unions Act 1926, and the Industrial Employment Standing Orders Act 1946. Okay, labor legislations ensuring labor welfare and minimum standards were also enacted. Some of them are the Factories Act 1948, and the Payment of Wages Act 1936, and the Payment of Bonus Act 1965. Okay, in India, a number of labor legislations have been enacted to promote the condition of the labor, keeping in view the development of industry and national economy. But for industrial regeneration, it is necessary that the partners of the industry must cure their respective defects. Since independence, both legislation and public opinion have done a lot to better the condition of the workers, but unfortunately the employees have not responded very apparently. Okay, it is the high time that the employer must realize that it is their privilege as a citizen of a democratic country to relinquish them accusative tendencies of the past and set a new ideal for the future of the country. Okay, at the same time, it is the duty of the workers and their organizations to improve the work efficiency and help in securing better production, resulting in greater profits and prosperity of the industry to be ultimately shared by the management, workers, and the community in large. Okay, the employers should consider into workers a representative voice in the control of the industrial system. Workers are the dominant partners in the industrial undertakings, and without their cooperation and good work, okay, the discipline, integrity, and character, the industry will not be able to produce effective results of profits. Okay, so that's good. However, efficient the machine touch in any industry may be if the human element refuses to cooperate, the industry will fail to run. Therefore, the profit of the industry must be shared between employees, workers, and the community. The workers having a dominant share, being the producers of wealth, etc. Okay, of wealth, etc. Then principles to follow for making labor legislation. Okay, principles to follow making labor legislation. Okay, that's good. As a matter of fact, okay, labor legislation in any country should be based on the principles of social justice, social equality, what is it, international uniformity, and national economy, which are as follows. Okay, that's good. Then one is social justice. Okay, social justice implies two things. First, equitable distribution of profits. Okay, first is equal distributions of profits and other benefits of industry between industry owner and workers. Secondly, providing protection to the workers against harmful effects to their health, safety, and safety and morality. In the beginning, the position of a worker was that of a daily wage internet. Okay, daily wage earner, which means he was paid only for the days he actually worked. A workman was expected to accept all the hazards connected with his work as incidental to his employment until the passing of Workmen's Compensation Act 1923. No compensation was paid in case of an accident taking place in the course of employment. So this question part 1. Okay, this is part A. Okay, this is still part A. Okay, so to be continued. Okay, the Minimum Wages Act 1948, the Factories Act 1948, and the Partners on the Payment of Wages Act 1936 are a few other legislations based on the principles of social justice. Okay, this legislation fix the hours of work, make provision for payment of over time. Okay, leave rules, safety, health, and welfare of labor and in industry. The labor welfare in our country has a special significance for the Constitution provides for the promotion of welfare of people, for human conditions of work, and securing to all workers okay, full employment of leisure and social and cultural opportunities. The word social justice is neither defined in any of the labor legislations nor use if occur in any of them except the Industrial Disputes Act 1947. When the Industrial Disputes Act 1947 was amended in 1956, yes, 17A Clause 1 uses the words social justice. Okay, Article 38 of the Constitution provides that, Article 38, okay, that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may social order, in which justice, social, economic, and political shall inform all the instrument of the national life. Article 39 ordains that it shall be the duty of the state to apply certain principles of social justice to making laws. Then second point is social equity. Okay, this is the side heading. Okay, any legislation which is based on social justice prescribes a definite standard for adoption in future. Okay, such a standard in fix is fixed after taking into account the past and present as circumstances. Once a standard is so fixed by legislation to remain in forces until it is charged or modified by another legislation passed in conformity with the legislative procedure. Then third point is that, then third side in social security. The concept of social security is based on ideals of human dignity and social justice. Okay, the underlying idea behind social security measures is that a citizen who has contributed or is likely to contribute to his country's welfare should be given protection against certain hazards. Okay, certain hazards, that's good. Then certain hazards, then social security means a guarantee provided by the state through its appropriate agencies against certain risks to which the members of the society may be exposed. Social assistance shrine social assistance scheme provides benefit for persons of small means, granted as of right its amount sufficient to meet a minimum standard of need and financial from taxation. Okay, and financial from taxation. And social insurance scheme provides benefits for persons of small earnings, granted as of right in amount which combine the contributory effort of the insured with subsidies from the employer and the state, etc. So this is the company, this is the labor law. In labor law, this is the first question. Okay, so that's the thing. Okay, thanks friends. Just I want to share my experience with you. Okay friends.